Good evening. Today, good evening. My name is Juan Vega, and today I'm going to be presenting our case of Bostock versus Clayton County. The major question on this case, of course, is if Title VII of the Civil Rights Act of 1964, which essentially currently prohibits against employment discrimination because of sex, should that um, Civil Rights Act protect against employment discrimination based on individuals' sexual orientation. Of course, to understand this case, there's a couple of dates that are really important to the case. The very first one, which is May 10th of 2018, once a case was brought up, the 11th Circuit actually affirmed the judgment of the North District of Georgia, May 27, 2018. Bostock actually filed a petition with the U.S. Supreme Court on April 22nd of 2019. The U.S. Supreme Court agreed to actually hear the case. And then on October 8th of 2019, the U.S. Supreme Court actually heard an oral argument. And of course, the decision was actually made on June 15 of 2020, where the U.S. Supreme Court reversed the 11th Circuit's ruling and remanded the case. So we'll be reviewing how the case actually came along. Now, on June 15, 2020, Bostock versus Clayton, Clayton County, which is essentially the city of Georgia, actually found its place in history as a landmark. As a U.S. Supreme Court case heard LGBTQ rights in the workplace. Now, as we all know, and we've all heard so many stories and so many cases in which perhaps the LGBTQ community has actually not seen the rights that they're actually entitled to. And then, of course, there's the opposing of it as to, if they should have the same rights or not. So we'll be reviewing this a little bit more. But of course, the Bostock case actually expanded the definition of sex in Title VII of the Civil Rights Act, which now prohibits employers from discriminating against employees because of their sexual orientation or gender identity. We'll talk a little bit more about it as there is a reasoning as to why a court will actually hear the case, as essentially the law has to be interpreted as well. So we'll go ahead and talk a little bit about what Gerald Lynn Bostock actually went through and how the case came into effect. Now, Gerald Lynn Bostock actually filed initially a charge of discrimination with the Equal Employment Opportunity Commission due to his termination from Clayton County. And as you know, any employee could actually get terminated on basis of performance or anything that has to do with their work. But in his case, Gerald actually began working with Clayton County, Georgia, as a welfare services coordinator in 2003. Now, during his 10-year career with Clayton County, Bostock received positive performance evaluations, and for that he was a great employee. But in 2013, Bostock actually began to participate in a gay softball league, which was not harming anyone. But shortly after, during a meeting, of course, in which Bostock's supervisor was present, at least one coworker actually, openly made some remarks about his sexual orientation. Shortly after the meeting, Clayton County actually informed Bostock that it was actually going to be conducting an internal audit of the program that he was actually managing. And then shortly after, his employment was terminated, of course, for conduct unbecoming of its employees. Now, of course, this is based on interpretation, right? The timeline actually, shows, or at least the optics of it shows as due to the fact that he began participating in a gay softball league, it actually led to his termination, which is the reason why he actually filed a charge with the EEOC. But then shortly after, within months of his termination, Bostock actually filed a charge for discrimination. And then 3 years later, in 2016, he actually filed a lawsuit against the county alleging discrimination based on sexual orientation within the Title VII of the Civil Rights Act of 1964. Now, the district court actually dismissed the case on the findings that the claim, was just based on an interpretation of Title VII, and not essentially that he was actually discriminated based on his sexual orientation. Bostock didn't believe in it or didn't believe in the decision that was made, and he was actually able to appeal. And the U.S. Court of Appeals for the 11th Circuit still affirmed the lower court, stating that it was actually essentially an interpretation of such. Now, one of the things that, of course, first we need to understand is Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, and national origin. Many will ask as to where does sexual orientation come into play? Many will actually say that it's based on the word sex within the Civil Rights Act. But as well, we go back, back and forth as to what courts normally interpret, like any other law. It's never black or white. There's always that gray area where we kind of have to interpret, and a lot of things come into play, which in this case. Now, discrimination on the basis of homosexuality or transgender interpretation. Now, the discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat employees differently because of their sex. The very practice, Title VII prohibits in all manifestations. Now, although it's acknowledged that a few in 1964 will have expected Title VII to apply to discrimination about sexual orientation, the court has no weight on it. Now, we go back again as to how the courts in every court actually interprets Title VII. And this is one of the actual cases that actually goes along with that. Now, one of the things that I kind of wanted to explain at first is what sexual orientation is. Many of us know what it is, but according to the American Psychological Association, sexual orientation refers to a person's sexual and emotional attraction to other people and the behavior and or social affiliation that may result from that attraction. So as we both know, and as everyone knows, the sex that you're actually born at is one thing, and then sexual orientation is a different thing. But essentially, it is believed, or at least it is interpreted, that Title VII should be protecting sexual orientation as well. Now, all of this was actually brought up to the court, and then it was actually decided that an employer who fires an individual employee merely for being gay or transgender actually violates Title VII of the Civil Rights Act of 1964. Now, Justice Neal actually authored the opinion for the 6-3 majority of the court. And as you know, with any court and then within our system, we also allow other judges or other justices to actually, provide their opinion as well. But to continue with what was decided is, it was decided that Title VII prohibits employers from discriminating against any individual because of such individual race, color, religion, sex, or national origin. Now, looking into the ordinary public meaning of each word and phrasing compromising that provision, the court actually interpreted to mean that an employer violates the Title VII when it intentionally fires an individual employee based at least in part on sex. Now, discrimination on the base of being a homosexual or transgender status requires that an employer to intentionally treat employees differently because of their sex. Now, the very practice of Title VII prohibits in all manifestations. Although it acknowledges that a few in 1964 would have assumed that everyone would have actually, seen the Civil Rights Act as, any type of discrimination based on sex, sexual orientation. But this is something that, time to time we actually have to revisit. And this comes with, other justices' opinions. Justice Samuel actually authored a different opinion in which, criticizing the majority for attempting to pass off its decision as an inevitable product of, statutory interpretations. Now, a lot, may decide or may actually think that it does not protect sexual orientation as it is not part of the Civil Rights Act, or that it's not actually stated as such. But the outcome of the case, of course, is where the court actually, reversed the judgment of the United States Court of Appeal of the 11th Circuit, in which, again, it actually states that any employer who fires an individual merely of being gay or transgender actually violates Title VII. Now, one of the things as employers should look into is they should review their employment practices to ensure that their employee-related matters are actually documented in order to provide enough evidence that they're actually treating all of their employees equally without any type of discrimination or retaliation. This is something that essentially all employers have to, look into. Small, big employers, or even, self owners, or public trading companies as well. Um, And then, of course, for any of their information, definitely here are the sources. There's tons of information as to where we can find a lot of information about the case, the different interpretations as to the case. Because one of the major things that we also have to take into, Bostock just opened that up where it was interpreted that that was discrimination. Yet, as any individual trying to actually use the Bostock versus Clayton County case, you still need to actually be able to prove that the basis of the termination was basis on just strictly sexual orientation. And if you were not of that sexual orientation, you would have still been employed with the company. So that's one of the major things that, of course, as counsel has to actually be able to prove to the court in order to actually get a favorable decision. And that is about it. Thank you.